Welcome to our video giving an overview of a debt collection case. You are here because you have a debt collection matter in court. This means somebody says you owe them money. The person claiming you owe them money is the plaintiff. They can also be called a creditor or a debt collector. In these matters, you are the defendant. Debt collection case starts with a complaint or summons. The plaintiff says they served you with papers that were filed in court. As the defendant, you have a responsibility to respond. You probably already have done this by submitting an answer to the court clerk and to the plaintiff. This is necessary. It is what lets the judge know you have something you want the court to hear about your case. The complaint and answer together are referred to as pleadings in court. Next is discovery. This is the investigation stage of the lawsuit, where each side has a chance to ask questions of the other side and tell their story. This step is how the parties get to the bottom of the issues the judge will ultimately decide. First, you will have initial disclosures. You may have already received things like the contract, an account statement, proof of payments, correspondence, and such. The plaintiff will send you this type of information. You also need to give copies of any documents, receipts, communications, or information about any witnesses that you may have to the court and to the other side. This is the evidence which each side presents to make arguments and prove their case. There will also be discovery requests. During discovery, both sides can request documents, send something called interrogatories, which is just another way of saying written questions. And with these, you can ask things like, what proof do you have that I owe this debt? Or how much was I charged for the test you claim I owe? You can also ask for admissions. For example, they can send you a document that says, admit you received a fill in the blank. It could be a service or a product. This is anything that helps narrow the facts being disputed. If you do not deny them in writing, the court will treat these admissions as true. They're usually called requests for admission or requests for production of documents. This is very important. It means that you received a request and you must respond. If you don't respond, you can lose your case. Your answer or other information you have already given does not count as a response to these discovery requests. You must give a separate new response to each request that you receive. After discovery, you'll often see motions filed. This is where you can ask the judge to decide something. It may be a final decision, or it may just be something to move the case forward, like permission for alternative service or a fee waiver, something that needs to happen in order for the case to proceed. Most of these are for summary judgment or a judgment on the pleadings. These ask for a final judgment against you because the facts or your failure to respond to admissions show by law that the debt collector should win and receive a judgment against you for money. Or you may file a defense motion. You can say their case is faulty. There may be problems, like the plaintiff can't meet his burden of proof. This means you should prevail and the case should be dismissed. Once discovery is done and motions are resolved, you'll move into the pre-trial phase. During pre-trial, you may be called into court for a pre-trial conference with the judge and the opposing side. This is an opportunity to decide what needs to be done to get the case to trial. It is also a time to consider whether you can negotiate and reach a settlement before the trial even happens. You're required to make pretrial disclosures. Again, this is where you identify the documents and witnesses you plan to use at trial to make your case. If you do not tell the other side and the court this information, then you will not be allowed to use it or call your witnesses when you do go to trial. So be sure to make everything that you intend to use at trial known to both the court and to the other side. If after this pretrial stage you still have not resolved your case, then you will have a trial. A trial is not really like something you see on TV or in the movies. They're not nearly as exciting. Ultimately, each side makes an opening argument, they present witnesses and documents, and then they make a closing argument. At that point, the court will make an order, a finding, or a judgment. This is where the judge announces the results of the case, who wins, how much for damages, and other issues like that. This is a final order and resolves the case. Thank you so much for taking the time to watch and learn more about the debt collection process. If you have more questions about this, be sure to use the options given in the video about free resources. Thank you, and we wish you the best.